Hello everyone. Welcome again to online session of Manu Law Classes. I'm Dinesh Kumar and I'm former Assistant Professor of Law at Campus Law Center, Law Faculty, Delhi University. And presently I'm working as an academic head of Manu Law Classes. So dear students, in today's session I will discuss with you one of the landmark judgment of Hon'ble Supreme Court in the case of Shreya Singhal versus Union of India 2015. Dear students, the date of CLAT examination 2022 is 8 May 2022. And date of CLAT examination 2023 is 18 December 2020. So prepare yourself accordingly. One more information, your application form are open on the website of NLU Consortium and the last date to fill the form is 31st March 2022. So please fill your form timely and wish you all the best. So in today's session, I will discuss with you these legal provisions and constitution provisions. First of all, I will discuss Article 14 of Constitution of India. So basically, Article 14 of Constitution of India provides for equality before law and equal protection of laws. I will discuss this article in relation to the judgment of Hon'ble Supreme Court in the case of Shreya Singhal versus Union of India. Next, I will discuss Article 19 of Constitution of India. So Article 19 of Constitution of India provides various freedoms to the citizens of India. I will particularly discuss here Article 19(1)(a) of Constitution of India. Means I will not discuss the whole Article 19 because that is not relevant here. I will confine myself to only to the Article 19(1)(a). So Article 19(1)(a) provides for right to speech and expression in reference to this particular case, that is Shreya Singhal versus Union of India. I will also discuss with you Section 66A. So basically, Section 66A is the section of Information Technology Act, and it provides that if any person post any offensive content on social media, means अगर कोई भी पर्सन किसी ऑफेंसिव कंटेंट को सोशल मीडिया पर अपलोड करता है या पोस्ट करता है, then this section makes this post as a punishable offense and the maximum punishment here is up to 3 years. Means अगर कोई पर्सन सोशल मीडिया पर या किसी कंप्यूटर रिसोर्सेज के द्वारा कोई ऑफेंसिव कंटेंट पोस्ट करता है, then such person shall be liable for the punishment which may extend up to 3 years. But what is the meaning of offensive content? It has not been explained in the section itself. So now we come to the facts of this case. The facts of this case are that in 2012, 2 girls were arrested by the Mumbai police. And the reason was that these girls posted some offensive content about Shiv Sena chief, late Shri Bal Thackeray ji. So when these girls posted some offensive content regarding the late Shri Bala Sahib Thackeray ji, then these were arrested by the police. So when these girls were arrested by the police, there was huge protest regarding their arrest, and various writ petitions were filed in Hon'ble Supreme Court that the action of Mumbai police is against Article 19 of Constitution of India, and 19 means particularly 19(1)(a), that they have violated their right to speech and expression. And right to speech and expression is a fundamental right and which cannot be taken away by any law. Now the legal issue before Hon'ble Supreme Court in this case was that whether section 66A of Information Technology Act is unconstitutional. Unconstitutional here means whether it is against any provision of Constitution of India. Second was that whether it is against Article 19(1)A of Constitution of India. And third issue was that whether this section is against Article 14 of Constitution of India. So as I discussed with you, Article 14 provides for right to equality, and which include equality before law and equal protection of laws. So in this case, the petitioner raised the following contention, and the first contention of the petitioner was that section 66A is unconstitutional. And why it is unconstitutional? Because it is against Article 19(1)A of Constitution of India, which guarantees right to freedom of speech and expression as a fundamental right. And the section 66A prohibits the exercise of this particular right. And this makes posting something on social media as a punishable offense. So on this ground, it was contended by the petitioner that this section is against Article 19(1)A of Constitution of India. Secondly, here the term offensive content has been used. Term offensive content has been used, and this term or this expression offensive content has not been defined by the legislature in this particular section. So it gives arbitrary power to the police, or other authorities, that they may give very wide interpretations to this term offensive content, and by giving wider interpretation to this term offensive content, they may violate the fundamental rights of citizens of India. Third, this section 66A is outside the purview of Article 19, Clause 2 of Constitution of India. So basically, Article 19, Clause 1, Subclause A gives us the right to speech and expression, but this right to speech and expression is not subject to, is not absolute right. Rather, it is subject to some reasonable restrictions. And these reasonable restrictions have been given under Article 19, Clause 2. So this right can be curtailed only on the grounds which are mentioned under Article 19, Clause 2. कौन सी grounds यहाँ पर mentioned है? I am giving reference of some of them, like security of state, sovereignty of state, integrity of India. Fourth is incitement of offense. Fifth is defamation. Sixth is contempt of court. And seven is decency and morality. So the word offensive content does not fall in any of the restrictions mentioned under Article 19, Clause 2. So that's why it is arbitrary, and it is outside the purview of restrictions mentioned under Article 19, Clause 2 of Constitution of India. Now we come to the contentions of respondent. So the respondent contended that it is the duty of legislature to make the law and protect the law, protect the right of other persons as well. For example, in the case of these girls made some comment about the late Shri Balasaheb Thackeray ji. So, and it also says that since the judiciary is independent, it can give the wider interpretations to the law if it thinks that it is not appropriate in any manner. Now, according to the contention of this respondent, the legislature believes that this dispute is legal. Means this section is legal and it is not the violation of any fundamental right as per contended by the petitioner. Now, respondent further contended that merely on the probability or merely on the basis of apprehension that this section takes away or abridges any of the fundamental rights of any citizen of India, this section cannot be declared as null and void. So this was contended by the respondent that you cannot declare a section as unconstitutional merely on the basis of apprehension that this section may violate the right of citizens of India. Now, since according to the respondent, this law is not arbitrary, so it is also not against Article 14 of Constitution of India. And if it is not against Article 14, so it is constitutional and it cannot be considered as unconstitutional. It is constitutional and it cannot be considered as unconstitutional. So Honorable Supreme Court, after analyzing the contention of both the parties, came to the conclusion that this section 66A is unconstitutional. Why it was considered as unconstitutional? Because it violates the freedom of speech and expression. Why it was considered that it violates the freedom of speech and expression? Because the restriction imposed by this section does not fall under section 19, under article 19 clause 2 of Constitution of India. जो रेस्ट्रिक्शन इस सेक्शन के द्वारा इंपोज की गई हैं, लाइक द टर्म ऑफेंसिव कंटेंट, तो ये ऑफेंसिव कंटेंट पोस्ट करना 19 क्लॉज 2 के किसी भी रेस्ट्रिक्शन में नहीं आता। इसलिए ये जो रेस्ट्रिक्शन इंपोज की गई है, दिस इज आउटसाइड द परव्यू ऑफ आर्टिकल 19 क्लॉज 2, और आर्टिकल 19 क्लॉज 1 सब क्लॉज ए पर जो रेस्ट्रिक्शन लगाई जा सकती है वो केवल वही रेस्ट्रिक्शन लगाई जा सकती हैं जो कि 19 क्लॉज 2 में दी गई है। अगर कोई रेस्ट्रिक्शंस 19 क्लॉज 2 में नहीं दी गई है तो वो रेस्ट्रिक्शन 19(1)(a) पर नहीं लगाई जा सकती। दिस वाज द व्यू ऑफ ऑनरेबल सुप्रीम कोर्ट। So Honorable Supreme Court also held that this section is against Article 14 of Constitution of India as well. Why it is against? Because it was held by Honorable Court that this section 66A is arbitrary in nature. It is arbitrary in nature. Arbitrary in nature क्यों है? क्योंकि यहाँ पर एक सिंपल वर्ड यूज किया गया है, ऑफेंसिव कंटेंट, एंड दिस वर्ड मे बी मिसयूज्ड बाय द कंसर्न्ड अथॉरिटीज, एंड बाय मिसयूजिंग दिस वर्ड concerned authorities may violate the fundamental right of citizen of India. So this was also considered by Honorable Supreme Court as violative of Article 14 of Constitution of India. So that's all for today, my dear students. I will come again with the next topic or next landmark judgment. Till then, thank you very much. Goodbye. Please take care of yourself and follow the COVID guidelines.